It is that time, it's a Tuesday. So we talk about legal matters, but then also we talk about matters tech. Later on, we'll have Paula Kwabe in studio. But right now, we do have an advocate of the High Court, Lawrence Obonyo. Good morning.
Good morning to you.
How are you?
Fine, thank you.
Welcome back.
Thank you for having me today.
I'm saying welcome back because it's been, a long Easter weekend.
Yes. It's been a restful one for us.
It has.
Yes.
All right. So we want to understand the legal framework for eviction in Kenya.
Yes.
And eviction happens in different ways. But first, in Mombasa, so when the government is building affordable housing,
Yes.
In some areas, the Kenya government has evicted residents to implement the affordable housing project.
Yes.
Right? And one of them is Buxton. Mm-hmm. One of the areas is Buxton.
Yes.
Let's start with, how does it begin? Is there a notice? Is there a notice? Is there a document I'm supposed to sign? And then also, how does the government also decide that this building now, this is what we want to use as affordable housing, and then now we need these people to go?
Okay.
Yeah.
Thank you very much for the question. Buxton Point is one good example of a development that fits within the bill in terms of what you've asked. But to answer the question directly, there can never be eviction or removal of anyone who is occupying any parcel of land without following due procedure.
Okay.
Due procedure is a notice, and a notice serves two purposes. A notice serves the purpose of the giver of the notice to notify, to let you know that my intention is this and this. And for the receiver is to give you an opportunity to challenge that if you so need to, okay, or you so wish to challenge that.
Yeah. So
a notice is mandatory, that you must be given a notice before anything is done, because that even falls within the ambit of natural justice, the rules of natural justice. For someone to wake up one day and tell you to vacate a premise or something like that, then it would not be right. But before the government does that, they need to have ownership or have a way that they own that property that they are evicting you from,
yeah,
or giving you a notice to vacate from. So that aspect of ownership is important.
Yeah.
So even when we are discussing how the notice came and whether it's legal or not, we need to understand that we need to go back to the aspect of ownership.
Okay.
The government cannot give you a notice to vacate a premise or a piece of land that does not belong to it. So essentially, when we are looking at some of our clients and the general populace, people complaining and having genuine complaints, then we need to understand that the basis of it all is that this land has to have belonged to the government.
Okay.
Buxton Point is very unique because the developer was not the government, and the parcel of land was held through the county government, the former municipal council of Mombasa, now county government of Mombasa. And the process was, as you stated, a notice was given, some sort of compensation was given was proposed. So some people were compensated, the ones who cooperated, there are others who never cooperated, and we still have the issues that are alive and active within courts and within the different areas. For example, there's a Senate committee that had already recommended for the county government of Mombasa to ensure that compensation is done. And the county government of Mombasa was also very, very good in terms of what they had proposed to do with this particular development. If you go to the nitty-gritties of this development of Buxton Point, it was not only compensation, but there was a subsidized offer that was given to some of the people who were the occupants, yeah, to become owners of the buildings that were built afterwards by the developer at a subsidized cost. So if you and I were going there and we never had any occupancy there, then we would go at a different rate compared to, let's say, if Gona was there and they were occupants, then they would get a more subsidized rate.
Yeah.
Now, the county government of Mombasa had this revelation during the Senate hearings that was a bit surprising, that actually the developer had handed over only a few units to the county government of Mombasa that they could give. The rest were to be sold by the developer. So this is some sort of joint venture that is between the developer and the county government. and a contract is a contract. Their hands are tied. They can only give what they have. So if the other units did not belong to the county government for whatever reason that they got into that joint venture like that, then that is not theirs to give. So I hear there's a phase 2 that is coming up, and some of the people who missed out on phase 1 are being offered or given promises on phase 2. But these are the things that are still
in court.
Yes.
Okay.
Not only in court, but also in the different areas of discussion, like the Senate, and also the county government is also discussing the same with some of the affected parties.
Okay. So I want to take you back to, you said, first of all, it has to be owned by the government,
Yes,
right?
yes.
For government to issue an eviction notice.
Yes.
Now, if it's owned by the government, how long should an eviction notice be for? And why are we seeing a resistance where the tenants who cooperated and then the tenants who did not?
Okay. Directly is to go to the question directly. There is no standard timeline for a notice. There is what you can challenge as too short of a notice, but there is no standard. Now, this is something that it is up for interpretation.
Yeah.
If I am a tenant and the normal procedure or standard is that you're given maybe a 1 month or 2 month notice, this gives you sufficient time to maybe challenge if you want that. But if you are enjoying a long lease, then the ideology is that a long lease would be something that you've been there, or you have the mentality that you're going to be there for about 99 years, for more than 5 years, for more than 10 years. Then the ideology is that you being rooted there in a certain way, 30 days or 60 days would not be sufficient. So you would be looking for something like more than 6 months for you to look for alternative accommodation, to look for a way to even dismantle your developments there and relocate them, things like that. So this is what we leave to the courts for interpretation in the event parties don't agree. You've asked the second limb of the question is that why is there resistance? Most resistance is coming from two things. Number one, if someone feels like the notice is too short. And number two, if someone feels like the legitimate expectation that they had on this particular occupancy has not been met. Let's say the place that you were given was for you to stay, but it was almost indefinitely.
Yeah.
Then one day someone wakes up. So you expected and you had made plans for an indefinite stay in that place. And someone else wakes up and tells you that actually now we are cashing in on the favor that we had given you. We are taking back the parcel of land. So because you're aggrieved, because you find that some of the people who are there are second or third generational owners, the people who had been passed down from their older folks or something like that. So they had that expectation that I'd be staying here for the longest. Now the question is whether that expectation is realistic or not. And this is where we now have these issues that are in court.
Is it realistic though if the land is not yours? If the property is not yours?
Taking an example of occupancy of a house, then this is not realistic. And this is not a legal perspective. This is just a personal and interpretational aspect of it, from a logical look of it. But if you're talking about someone who's been given, maybe we're talking about land now, where you're not talking about a unit, a house, or a premise. Talk of a land, and you were given a lease or you were given an allotment letter, then that expectation is realistic, because some of the people who are given an allotment letter and they pay a rental amount to the county government, to the municipal government, to the government, and this letter had come with conditions that you're supposed to develop this place. Maybe they put up a 10-story building, and this story building has been approved by the same person who gave you the parcel of land. Then that expectation, legitimate expectation to stay there forever, is realistic. Yes.
Interesting. So I think still on that.
Yes.
Then why the compensation?
Compensation is it's actually an act of good faith.
Yeah.
It is not mandatory, but it's an act of good faith, especially now when we're talking about occupancy of ready-made units, like the case of Buxton Point. You've been given a house. So the question would be, why are we compensating you and you're living? You did not develop the place. You did not do anything. If anything, you just wore it down because you are utilizing it.
Yeah.
So it is just an act of good faith so that you can find a softer landing to deal with the legitimate expectation that you had, so that you can, on a humane basis. But when we're talking about those long leases, we're talking about those parcels of land that someone has developed, then that compensation is mandatory, because you invited me into your parcel of land. I was paying you land rent. You gave me conditions that I need to develop this place. I developed it. Then later on, you're telling me that I need to pull it down. When I need to pull it down, where will I get the compensation for the development that I made on your invite? Essentially, your invite now binds you to compensate me for the loss that I'm going to get.
Okay.
Yes.
Wakili Lawrence.
Naam.
Mfano tubaki kwenye huo mfano kabla tuende sijui Changamwe sijui Likoni. Tubaki kwenye huo mfano hapa Kisiwani.
Naam.
Kwamba wale watu walikuwa wakiishi pale na walikuwa wanalipa kodi kama sijakosea 3,000 na kitu kama hicho.
Ndio.
Na walikuwa wanalipa kwa wakati ulikuwa ni county.
Municipal.
Municipal ama sasa hivi si ni county.
Sasa hivi ni county.
County.
Naam.
Mara ghafla wakasema wenyewe wanataka kubadilisha sura ya mji.
Ndio.
Kwa sababu majumba yale yalikuwa yanakaa hivi. Wakajua ni serikali.
Ndio.
Lakini ikaja ni Lawrence ndiye ambaye kwamba amepewa kandarasi.
Ndio.
Ya kufanya hiki kitu.
Ndio.
Hawa wakaambiwa wao waondoke.
Ndio.
Hapa kwenye kuondoka, manake kulikuwa na watu ambao walikuwa wanaishi pale. Sasa hivi ni viongozi. Sawa. Na walikuwa wakali, lakini sasa hivi makali pia nayo
yameshuka.
Yameisha kwa sababu serikali kule juu imesema hii pia ni process ya ile kitu nyingine.
Naam.
So swali linakuja hapa.
Ndio.
Hawa waliposema wanataka kubadilisha sura ya mji, manake pale ni unatoka na unaingia.
Ndio.
Hawa waliokuwa wanaishi hapa na walikuwa wanalipa kodi. Sawa, sio kwao. Wao walikuwa wanaishi kwa kukodi. Na waliishi ni vizazi na vizazi. So tatizo hapa kuja kuambia sasa ni wakati wa kuondoka. Kwa nini ilibidi wawaspidishe?
Kunazo zile, kwa Kiswahili sina neno la government policy.
Mpango mkakati.
Mpango wa mikakati ya serikali. Wajua kama vile serikali tofauti zikija mamlakani, zina vitu ambavyo zinataka kutimiza. Katika serikali hii kutimiza mambo ya kupatia watu majumba au nyumba za kuishi za hali ya kisasa, mambo kama hayo ni kama jambo ambalo lilikuwa limepewa kipaumbele. Ili watimize mambo kama haya ilikuwa inabidi ya kuwa walisema na walitoa ahadi zao ya kuwa siku 100 ama siku fulani tutatimiza mambo kama haya. Na hiyo inalingana tu na hiyo mikakati ya serikali. Lakini swali ni wakati ambao watu walipewa nafasi ya kuondoka ama ile ilani ya kuondoka, iliwatosha kuondoka ama ilani hiyo ilikuwa muda huo ulikuwa mfupi zaidi? Kwa wale ambao walikuwa wanahisi ya kuwa muda huo haujatosha, wamepata nafasi ama walipata nafasi ya kwenda kotini ama kwenda katika vitengo tofauti ama kuzungumza na serikali ya county ili waweze kutatua mambo kama hayo. Lakini kujibu swali lako, ilani ile ilitosha, wakati ule ulitosha ama haukutosha? Kivyangu mimi nitaweza kusema ya kuwa kama hatujaona mtu ambaye ametoa tetesi kusema mimi nilitolewa kwa haraka ama pengine sikufidiwa ama mambo kama hayo ni tofauti. Lakini muda ule walipeana umekaa ni kama muda ulikuwa umetosha ili watu waweze kupata njia mbadala ya kupata makazi.
Tukiwa pale kwa mambo ya ilani, umeeleza vizuri kwamba inaweza kuwa mwezi mmoja ama miezi miwili.
Naam.
Na kama pengine mtu anahisi kama haijatosha, pengine anaweza kuenda ka challenge hiyo. Lakini je, ikifika kwa compensation, niangalie tu mfano wa pale Malindi Airport, kuna watu ambao waliweza kutolewa.
Ndio.
Lakini sasa wamekuwa wakienda kotini, wamesema zaidi ya miaka 10.
Ndio.
Na compensation bado haijafanyika. Je, kwa compensation wakati ukitolewa kuna ile ya kwamba sasa utakuwa umepewa muda kwamba maybe within this period tutakuwa tunawacompensate kwa sababu ya kuondoka, ama huwa inafaa kukua immediately ama iko vipi?
Kwanza inahuzunisha sana kusikia kuwa zaidi ya miaka 10 watu bado wanakibizana na mambo ya kufidiwa ama ile compensation hawajaweza kulipwa. Ni kama kuna mahali ambapo haki haitendeki somewhere. Kama ni jambo ambalo liko kotini, ni mambo ambayo wanafaa kufuatilizia, na wakili wao wahakikisha ya kuwa wakili anafuatilia, na hata kama ni kuandika barua. Unajua wakati mwingine kucheleweshwa kwa mambo inafaa kuangaliwa kwa njia tofauti. Usiwe tu unafuatilia njia moja ambayo haitoi mazao na bado umekwamilia pale. Tafuta njia mbadala. Sasa kwa swali lako, wakati ambapo mtu anafaa kufidiwa, anafaa kupewa fidia ya pesa fulani ama idadi fulani kwa kutolewa mahali fulani. Kwa kawaida koti huwa inatoa muda ambao unafaa kulipa, mtu ambaye amewatoa anafaa kulipa, na ikipita muda fulani kunayo ile itwaje, interest kwa Kiswahili inaitwa riba ambayo inatokea iwapo mtu anachelewa. Sasa kama ni serikali ambayo inachelewesha na ile riba inaendelea kupanda, basi yule ambaye anafaa kufidiwa ndiye ananufaika, lakini wakati huo bado atateseka. Sasa ni vizuri kama mtu anafaa kufidiwa, fidia itoke kwa wakati ambao unafaa, na ikiwa inacheleweshwa bado yule ambaye anachelewesha ataweza kuumia zaidi. Kwa hivyo kama kuna wakazi wa upande wa airport ambao wamecheleweshwa hivyo, zaidi cha msingi ni pengine utapata kuchelewa kule kunakuja kwa vile uamuzi haujatoka. Na pia kuna mambo mengine huwa yanajitokeza ambapo tuliona hata kama wakati watu walikuwa wanatolewa kwenye maeneo ya Dongo Kundu ama mambo kama hayo, ni fidia inatolewa, lakini wewe kama mtu binafsi unahisi ya kuwa fidia ile compensation haijatosha. Kwa hivyo unaenda kuichallenge, na ukienda kuichallenge muda unakawia, sababu pande zote mbili lazima zisikizwe. Lazima waweze kujieleza kwa nini tumewafidia, wapatia fidia ya shilingi 100,000 na mwingine 1,000,000. Lazima waweze kueleza, na ukiweza kuchallenge na ufaulu, unapata ya kuwa kuna ile interest inakuja juu yake, hiyo riba inakuja juu yake.
So the compensation plan inakuja huu wakati tu bado unapewa hii notice, ama inakujia time gani? Ni wewe mwenyewe ufuatilie, ama ni wakikupatia notice sasa ndio iko katika hiyo notice kwamba this is what you expect?
Kisheria inafaa kuwa katika ile notice, sababu hakuna haja ya kupatia mtu nafasi ya kwenda kuvutana kule. Notice inafaa kuwa na mambo kadhaa. Jambo la kwanza la notice inafaa kuwa na identity, ama wewe uweze kujua kutokana na ile notice ni nani anakupatia notice. Unaona, kama developer hafai kukupatia notice, ni mwenye shamba anakupatia notice. Sasa inafaa kuwa na hiyo. Jambo la pili inafaa kuwa kwenye notice ni yule anayepewa notice. Mimi kama pengine mimi ni mpangaji wako na wewe ndio unajulikana katika makaratasi kule, wewe ndio unapewa notice, sio mimi kama mpangaji wako. Jambo la tatu, unapewa identity ya mahali unapewa notice, ili tusije tukasema notice ilikuja lakini inafaa kuwa ya Likoni, lakini mimi naishi kule kisiwani kwingine, vile ambavyo mwenzangu anasema. Jambo la 4 ambalo linafaa kuwa kwenye notice ni muda ambao unapewa. Jambo la 5 ni sababu ambayo unatolewa pale. Unanielewa? Hauambiwi tu sasa toka, unapewa sababu, unapewa muda, na unapewa jambo lingine ni ile kama kuna compensation katika hiyo notice, katika hiyo process unaambiwa kutakuwa na compensation. Kama ni 1%, utaambiwa ni 1% fulani, ama watakupatia ile formula ya kufikia ile compensation. Kama hakuna formula watakuambia directly ni pesa fulani. Unanipata? Alafu jambo la mwisho wanakupatia nafasi ya kuchallenge your notice. Hizo ndio the legal requirements of a notice. Unapewa an opportunity. If you are not happy with this, please feel free to pursue a legal recourse. Unanipata? Hapo ndipo sasa utasema notice ama ilani ile imekamilika kisheria. Yes.
Okay, so still on what Gwana has asked, when you're talking about compensation,
yes.
Okay, fine. So they've given me a reason to evict me. They've told me they've given me a period as well, like you said,
Yes.
and then also that the compensation is there. Now, this is something that I wasn't that I'd not planned, like you said, for the residents in Buxton, right?
Yes.
And pretty much most of them were like, we're going to stay here for eternity.
Yes.
If there's such a thing. Now, this compensation, because I had not planned, I had not made plans to move.
Yes.
Will this compensation come before, or because I didn't make plans to move. You
Yes.
decided that you want to move me, but you see, I didn't make plans to move. Should this compensation come before I move so that it may help me in moving? Or is it going to come after, which is now the push and pull of give me, you've moved me, you've not paid me, I'm
Yes.
frustrated. How does it work?
Practically, or let me start with ideally. Ideally, a compensation should come simultaneous with the movement, or rather with the moving, or vacation, the vacating of the premises.
Yeah.
But practically, compensation comes after. Because some people have dealt, the people who've been given them compensation or notices a raw deal. You can compensate someone in advance. They utilize the finances that you have given them to challenge this. So they've taken your money, so it becomes now a civil debt.
Yeah.
So it becomes a situation whereby I gave you money, you're using that money to fight me.
Yeah.
I gave you money and you're sitting on that money. You refused to honor your part of the deal. So on an ideal situation, it's supposed to be simultaneous.
Yeah.
Just the same way you go for a normal trade. I exchange this for something else. You leave, you get your check, you go do whatever you're going to do with it. But on a practical basis, it's normally a checklist. Have they vacated? Have they done a handover? Then the check shall be following them later on.
Okay.
Which now gives us the same issues of, I have not been compensated. It's been at this time. It's been this time. Yes.
Now,
Sorry.
when you talk about now time to challenge, because there's also room to challenge this.
Yes.
You've given me a notice, and I feel like this is unfair. So I want to challenge it in court. Do I still stay in that house while we're going through this court process?
Ideally, that's why again we will market lawyers by saying that you need to get good counsel, because at the end of the day, if you get good counsel, then that counsel will make sure, or rather the lawyer will make sure that you get a temporary reprieve, so that before the case is determined, then you are not disturbed.
Okay.
But sometimes through action or inaction, you find that some people suffer certain consequences, that they are left homeless because they made the wrong move. They never asked for certain things. They never pushed for them. They never articulated them well. In some of the cases that we've handled and things that we are still handling up to date, still active in courts, you'll notice that there's an injunction that is stopping any eviction, any demolition, any movement of the people who've been served with notices until the final determination of the case.
Yeah.
So this has sometimes given the government a difficult time. Here we are talking about the head government, which has been on this side of giving the notices, a difficult time that they've had to reroute their projects, because the government is vast. They have more land, they have more resources, so they can reroute their developments elsewhere, so that the human rights and the expectations of the people on the ground are met through the courts process. Yes.
All right. We are speaking to an advocate of the High Court. We're speaking to Lawrence Obonyo. And we're looking at the legal framework for eviction in Kenya. Now we're out of we've talked about the government now evicting, but then there's also the eviction that comes from your landlord.
Yes.
And then there are also stubborn tenants, you know, who despite being given an eviction notice, they just don't want to leave.
Yes.
So I want to look at those two sides of the coin. What should the landlord do? And then you as a tenant, what are your rights in case that happens? We'll be talking about that in a bit. If you have any questions, 07009179117. Good morning. And in studio, we do have an advocate of the High Court, that is Lawrence Obonyo, from Lawrence Obonyo Legal Advocate. And we're talking about legal framework for eviction in Kenya. But now let's bring it to tenants.
Yes.
Now, okay. Now, before I bring it to tenants, Salim had a pressing question. Let's finish that, and then I'll bring it to tenants and then landlords.
Yeah. All right.
Wari yangu ni wakili kwamba walifikiaje hapa kwa 200,000 because hawa land haikuwa yao, kitu cha kwanza. Nyumba pia hazikuwa zao. Walikuwa wanalipa 3,000. So hiyo goodwill yenye unasema walifikiaje kwa 200, na kuna wengine walikuwa wanalipa less than 200. And then how come county government ilipata less hizo nyumba, zile nyingine zikaenda kwa developer, and then hawa wakaambia nyinyi mtasubiri the other phase yenye hiyo ya kusubiri we always don't know itakuja baada ya miaka mingapi. So hapo kizungumkuti kilikuja kujaje?
Maswali ni mawili au matatu. Swali la kwanza, waliafikiaje 200,000 kwa watu wengine na wengine wakapewa kidogo ama chini ya 200,000? Hiyo kusema ule ukweli nitasema tu hiyo ni internal mechanism ya county government na kujua vile ambavyo wanapiga mahesabu yao. Lakini mimi nikijaribu kufikiria, walikuwa wanajaribu kutazamia kuwa 200,000 itaweza kuwatosha watu ambao wanafaa kuondoka mahali pale ama kurelocate kwenda kwingine. Na pia uamuzi wa watu ni tofauti. Mtu anaweza tumia 200,000 kuchukua ile offer ya pili, ile ambao walikuwa nasema watapata katika subsidized rate. Waseme hiyo 200,000 iwe ni kama the initial deposit yao, ambapo wata top up kwenye huo mpango wa rent to own ambavyo Senate ilipata wakati ambapo bwana governor wa county ya Mombasa alipokuwa anajibu maswali katika Senate juzi. Alisema kulikuwa na hiyo option ya rent to own. Unfortunately, mambo kama hayo bado hajafikiwa, sababu watu wengine wameambiwa wait for the second phase. Now hiyo inatupeleka katika swali lako la pili, ilifikiaje ya kuwa mkandarasi ama yule developer anapewa ama anachukua zaidi units zaidi kushinda yule ambaye anapeana project yenyewe. Tulisema mkataba ukienda katika kutia saini mkataba ni uamuzi wako na ujuzi wako na wale wataalamu utaleta mezani. Hasa wataalamu ambao tunazungumzia ni mawakili kama sisi. Chukua wakili wako ambaye ataangalia, wajua kila mwamba ngoma
anavutia kwake.
Sasa yule
usisahau na hiyo ngoma ukipiga sana hapa suka kiwambo.
Sasa yule mkandarasi, yule developer lazima alipiga mahesabu yake akaona ya kuwa kwa vile yeye kwa kizungu au kimombo tunaita commercial argument. Yeye kulingana na ile commercial sense, ita make commercial sense akichukua units kadhaa katika kile kisheria tunaita joint venture. Sasa waliingia katika ile joint venture na county pia wakaona pengine hawagaramiki sana. Wao wanapeana tu kipande cha shamba na wanapeana fidia, huku wanapata mambo mengine. Sasa ni kama yule mkandarasi alipata kuvutia ngoma upande wake vizuri, ndio wakapata hiyo na akatoboa. Hivyo ndivyo tunaweza isema. Lakini mambo kama haya bado nasema ya kuwa bado kuna Senate hearings, bado kuna county assembly mahali watu wanafaa kwenda, na kuna bwana governor ambaye anafaa kupeana taarifa yake kuhusiana na mambo kama haya. Maybe tumsubiri tupate kusikia kwa nini alipeana
kidogo.
Alipewa kidogo sababu ile ofisi ya governorship ni perpetual. Hawezi sema ati ni mtu fulani, ile ni ofisi iliyokuwa pale. Kwa hivyo yeye ata own up na kile kilifanyika hata before yeye. Yes.
Asante.
All right, thank you very much. I want to give a shout out to Terry Mongeli. Terry, good morning. Thank you for listening in. Now, Lawrence,
Yes.
can a landlord lock out a tenant in Kenya?
Wow, that's a heavily laden question. It's a very, very loaded question. Can a landlord lock out a tenant? What do you mean lock out?
Yeah, like I'm going home.
Yes.
I find that there's a padlock.
Yes.
Kila kitu, because I have, of course, reasons.
Yes.
Could be because I haven't paid that particular month's rent.
Mm-hmm.
And what's the other reason? I think, yeah, most of the time it's usually because as a tenant,
Hujalipa.
mimi sijalipa rent.
Ni cumulative.
Umechelewa.
No.
Umechelewa kulipa.
Kuchelewa is different.
You still have not paid.
Where?
Anyway, the short answer is it can only happen through a court order. Yes, it should only happen through a court order.
Where?
Okay.
Kama kuna mtu nafaa
Wajua, kuamka siku moja na kumfungia mtu bila kupata idhini ya koti.
Yeah.
Yes, you will be. I'm seeing the shock in your face, Maria, but you will be arguing that it's my asset. It's my. But there are rules that come into play.
Hata anakaa vizuri.
Kuna rules na kuna regulations zile
Yes.
vitu zinafaa kufanyika. Sababu leo mimi nikiwa mpangaji nimekuja nimepata umenifungia nyumba.
Yeah.
Na nilikuwa nataka kuingia pale. What is the expectation of where I'm going to go and things like that? Where is the humanity in that? Where is the due process? Uliniambia utanifungia nyumba, ulinipatia ilani ya kutoka nikakataa, vitu kama hivyo. Sasa utapata kesho yake ama siku hiyo hiyo kama nimerudi mapema na koti bado zimefunguliwa, nikaenda pale na kile kinaitwa reference. Wajua ukienda katika koti za kushughulikia zinaitwa tribunal.
Yeah.
Za kushughulikia mambo ya rent, the rent tribunal. Pale hauhitaji kutayarisha vitu vingi ama kwenda kwa wakili na mambo kama hayo. Ndio ukiwa na muda utaenda, lakini bado waweza kuenda na ufill form ambayo unaweka tetesi zako na order itolewe. Na hiyo order isemekane nenda umfungulie nyumba na usifunge nyumba hiyo mpaka kesi imalizike. Sasa
Okay.
nani atakuwa ameumia?
Okay, I like that.
Naweza kaa
Because
hapo kwa
Yes.
muda mpaka kesi isikizwe na silipi.
So due process, the main thing that we're talking about is due process has to be followed. We have rules and regulations, we have laws that guide how we relate to each other,
Yeah.
so that we don't have anarchy.
Okay.
Because,
So before so let's say you say he can only lock my house, or rather lock me out
Yes,
if there's
an order of the court.
yes, an order, a court order,
Yes,
right?
and the court, I mean here even the tribunal.
Okay.
Yes.
Now, before the court order.
Yes.
Okay, so now let's go back to this tenant
Yeah.
has not paid rent 2, 3, 4 months
Yes.
in, okay?
Okay.
We have a lease agreement,
Yes.
right? They have clearly not honored that lease agreement.
Yes.
And maybe there's also that process of, hey, you need to pay your rent, you need to do this, you need to do this, and then the tenant always says, I will, nangoja hi, I will. We do that a lot,
Yeah.
right? So the right thing for this landlord to do, you're saying, is to go to court.
Follow due procedure. Now you've introduced a very important thing.
Yes.
That there's a lease agreement between the parties. In that lease agreement, again, I bring you back to lawyers. When you have a lease agreement that has been prepared by a lawyer who knows what they're doing, the lease agreement will have a default clause. A default clause means that what if the tenant does not honor their part of the agreement? What if the landlord does not honor their part of the agreement?
Yeah.
What happens?
Yeah.
Then if it's provided there in that particular lease agreement, then the statement is clear. You just write a letter and execute. But if you do not have that, if it does not have, you do not have a lease agreement, that's one option. And then the other option is that you do not have a default clause that was put there. It was silent. You still have to go to court.
Okay. So before this landlord goes to court, what should he do, or should he or she do when it comes to communicating to this tenant?
Write a notice.
Yeah.
And let that notice have sufficient time for response, and give options because in the notice you can give an option, an ultimatum, that either pay within this period of time or vacate the premises. Before vacating the premises, make sure you put this and this, because in the clauses of the agreement you normally have return the premises in this form, or if there were deposits that are being held, they shall be utilized to fulfill 1, 2, 3. For instance, the classic one is painting the unit or the premises the way you found it, replacing locks and maybe window panes and things like that. So these are just the basic things that normally happen, and they are entailed in an agreement. But if you don't have an agreement, that's why sometimes they say within this coastal region, so many things happened based on trust. Yeah, gentleman's agreement, we've shaken hands and all that. Good as it may be for the society, it may also potentially bring the worst forms of legal battles on the other side.
Okay.
Because you as a landlord, you see that you're suffering because you never put everything in place. So it is not too expensive to get a lawyer to have everything written down.
Okay.
Yes.
So now we're looking at this tenant, and they have a lease agreement,
Yes.
right? You've talked about having the lawyer write down the lease agreement.
Yes.
Most times, you go to this again, the landlord,
Yes.
and they give you that lease to sign. We
Yes.
peruse through it, and then we just sign. We don't really look at the nitty-gritties. It's from them. Is there even provision for me to take this and say, I'm taking this to my lawyer to have a look, and then we can amend? Is there provision for that?
It is not written in the agreement, but remember, we would say this, but with utmost respect.
Yeah.
Ignorance of the law is not a defense. So the moment you're given any legal document, anything to look at, you always have an inherent right to take it to your person. Hata kama ni employment contract umepewa leo. You know, desperation gives us, takes away certain reasoning ability, that we are so desperate for this job, we are so desperate for this house, you're so desperate for this, so you just sign and give it back.
Yeah.
But inherently, the moment you say, can I have a look at this and come back to you, you go consult someone, have it looked at, and then say, I would wish for this and this to be amended. The other party will tell you, most certainly yes, or they will tell you, I don't want to amend that because of A, B, and C. And in the most difficult situations, they will listen to you and tell you, that's a standard document, we don't want to amend that. But you will still have raised your issues. So the answer is yes, you have an opportunity to take this document and come back with your own proposals.
Okay.
Yes.
So, okay. So this is because I know this happens. I know it's happening to somebody.
Yeah.
This person has not paid rent for a period of I think two months thereof.
Yeah.
Is the landlord allowed to, first of all, turn off your water, switch off your electricity? Those different ways to frustrate you, are they allowed to do that?
They're not allowed to do that.
Can one sue them for that, even though I'm the tenant, I'm the one on the wrong for not paying?
Yes. Yes, you can. The most ideal situation comes in when you see these service provisions that you're talking about.
Yeah.
If they're not part and parcel of the rent, then this should be provided by a third party. And only this third party has the mandate to do this. Like if it's Kenya Power, if it's Mombasa Water, they're the ones who can turn off that. What right do you have to cut off what you do not provide? Then,
Yeah.
if you had specifically indicated that this amount goes for rent, goes for water, this amount goes to electricity, and are you delegated to collect for and on behalf of Kenya Power? Do you have your own separate meter reading that you do all of this? As you said, these are ways to frustrate a tenant, so that you can force an eviction or a vacation from a premises, but they are not legal processes. The legal processes, no one would go to court and tell someone, now go cut off electricity today, go disconnect the water. Nobody would allow that. If you want someone to vacate the premises, then you have your legal remedies. There's a very classic old school barbaric way that they would do. Even someone would come and say they're taking off a part of the roof so that they make it, especially the bedroom, so that they make it difficult for you to stay there. Of course, that one you won't be able to challenge them because it's their premises. They are damaging their own premises, making it difficult for you to stay there.
Because it's their property.
It's their property. That is why I posed the question to you earlier on, that you're disconnecting water, you're disconnecting electricity. Do you have a mandate to do this for and on behalf of the provider? Remember, you're not the provider.
Yeah.
You're not the provider. You are only a conduit.
Oh, okay.
You have allowed for that service to come to someone who's there, but you're not the provider. So unless Kenya, then there's one thing I want to address. Maybe you have allowed for someone. You are the landlord. You've allowed for someone to stay in your premises for 3 or 4 months without paying. Excuse me. Possibly on a promise.
Yeah.
In law, we use the word acquiesce. Tunatumia kizungu kubwa kubwa. Acquiesce.
Yeah.
So when you acquiesce on your right, is that you are allowing certain things by conduct to pass just like that. So that when you claim that this person has not fulfilled their mandate, and you've allowed for that to happen for a long period of time, you have acquiesced on your right. You've sat on your right. So much that when you go claiming on it, the other person can use it against you.
How?
What was stopping you from raising an issue on the first month that they failed to pay?
I was being human.
The second month?
Well, I was being lenient and hoping that things would get better.
Third month? So what is stopping you from being human on the 4th, 5th, and 6th month?
Utafungwa. No.
So action has to be taken at the right time. Otherwise, you acquiesce on your right and you allow the other person to gain a legal perspective to actually challenge you for what you did not do.
So what you're saying is, as a landlord, if Gona does not pay rent we're in the month of April, right?
Yes.
In the month of April, Gona does not pay rent. I should start going through the legal process of
immediately
evicting him.
Write him a notice, give him ultimatums, so that you have actually paper trail and considerable things that people can refer to, that you're given a chance. You went through this and this and this and this. But if you just sit, maybe you don't need the money. Maybe you've done him charity and you've allowed him to stay there for free.
Please, wakili wacha sasa.
Hii ya notice kumpatia kama landlord. Is it pia naye ni assign abaki na copy na uwe na copy? Because na feel kama unaweza mpatia alafu yeye akapoteza yake akaseme huko ni sikuwa na pahali popote, ama inafaa kuaje hiyo notice?
Wajua katika ile tenancy agreement ambao nasisitiza wakili awaandikie, msirushe mawakili. Mawakili ni watu wanahitajika katika stages zote. Ile tenancy agreement itakupatia njia ya kupeana notice na njia ya kucommunicate. Ikiwa kwenye email, ikiwa kwenye WhatsApp, ikiwa kwa kupeana barua kupitia mkono. Then hata akirarua yake apoteze, yeye atakuwa amesha fulfill upande wake. Because in today's age, someone will say endorse on my copy, nimekupatia but sign yangu ya kuwa umepokea. Mtu anakataa kusign. What's the other option? Nimekutumia kwa WhatsApp, ime blue tick. Ama nimekutumia kwa WhatsApp, umekataa kuisoma, kuna grey tick 2. Lakini mimi naenda kwa Safaricom, napiga picha ya kuwa hii ni na najaribu kutumia shilingi 1, naona ya kuwa hii ni namba yako, naipiga picha, nachukua ile nini ya ile screenshot ya kile nilikutumia, na ziattach, naandika pale affidavit nilimfikishia na alipokea.
Hii kazi ya real estate kumbe ni ngumu.
Si real estate peke yake. Wajua hiyo ndio imekuwa adopted since wakati wa COVID. Tumeembrace mambo ya technology. Na tunajua si kila mtu atakuwa na email address. Lakini almost 95% of people wana simu. Na simu wana communicate nao hapa na pale, na WhatsApp iko hapo.
Wakili pia ulitaja kule kwa mimi ni mwenye nyumba
na nimekuja run out of questions.
No, I have something.
Nikatoa mabati kwa sababu nyumba ni yangu.
Yes.
Vitu za yule mwenyewe zikiharibika kwa mfano na mvua, msimu wa mvua, huyu haezi enda akashtaki sasa kwamba vitu zangu zimeharibika kwa sababu mwenyewe amekuja akang'oa mabati.
Akienda kushtaki ataulizwa swali moja. Uko na contract na yeye ama hamna contract? Remember, haujalipa. Wewe ndio unaishi pale. What was connecting the two of you was a contract of you paying na yeye ana provide nyumba. Wewe miezi 3 ama miezi 4 haujalipa, kwa hivyo ile contract haipo tena. Yule ameng'oa, wewe vitu vyako vimeharibika. Si wewe ni trespasser pale?
Okay, Salim.
kuna swali hapa. Umesema Miriam alikuwa ameuliza swala la hiyo frustration.
Ndio.
Maji na umeme.
Ndio.
In this era, kuna watu nyumba zao hawatumii nguvu za umeme za serikali.
Ndio.
Wanatumia solar na wengine wanatumia hizi silent generators.
Ndio.
Kwenye maji watu wanatumia visima. They don't use the government water. Amekata maji. Amekuondolea umeme. Amekiuka nani?
Amekata maji, ameondoa umeme.
Katika ni vyake.
Sasa maswali yatakuja pale vile ambavyo umetoa zile services. Katika ile agreement yako, let's say ulikuwa unamlipa shilingi 25,000.
Ndio.
Kuna mahali ilibainika ya kuwa pesa fulani zinaenda kwenye umeme na zingine zinaenda kwenye kuprovide maji. Kama haikubainika bado uko taabani, brother.
I say kitu ni ngumu.
So Lawrence.
Yes.
Now the landlords who also hold property.
Yes.
I remember a time I think when I moved in, that's in Nairobi.
Yes.
My caretaker, I didn't have seats. My house was very empty and my caretaker was like, kuna kiti na uzo hapa. What do you mean? So they had welcome shikilia.
Yes.
Somebody's items.
Yes.
A lot of things, and I said, no, I'm not buying that.
Yes.
Of course. But also there's that process where first of all they lock your door,
holding it in lien,
and then they hold off kila kitu, your property, and then
Yes.
they start figuring out how to sell.
Yes.
What's that?
Now, holding someone's property in lien is that aspect of kushikilia vitu vyako because uko na deni, and you know when you're vacating a premise you're supposed to clear, lakini haujaweza kuclear. There are places hata utaambiwa kabla kutoka kwenye gate unafaa kupata clearance ya upande ule na uwezi toa vitu vyovyote.
Yes.
Your movers, umeleta cube movers, hawezi ingia hapo without that clearance.
Yeah.
And if you have not paid, then they hold your items in lien because hakuna mahali watakupata tena. Wanaziweka storage, wanakuambia nenda umalizane kisha utakuja uchukue vitu vyako. Now here's the kicker. That one
It's allowed.
It's allowed because they are holding it in lien, but they cannot utilize, dispose of, sell or do anything to those items without an order of court.
Okay.
So vitu vyako vinaweza kaa tu hapo, watakucharge storage na vitu kama hivyo, lakini before they sell them they need to move the court, say that there's this debt that ilikuwa hapa, alikuwa na deni yetu, kuna vitu ambavyo vimeachwa hapa, we are seeking permission to dispose of this to settle the debt. Anything over and above we shall submit it to court so that imwendee yule, or we see how it goes.
So how does one get through how do you get a tenant to vacate your premise?
If the tenant is I'm assuming in this question we are talking about a tenant who is not fulfilling their part of the agreement.
Yes.
They're not paying rent, or maybe they are flouting other rules and things like that. The best way is to just give them a notice period to vacate, and just ensure that they are up to date with their legal obligations. Because when you give someone a notice to vacate, you don't want to enter into another phase of a legal fight because you've told them to vacate, but you didn't give them the condition that before vacating you need to have fulfilled your rental obligation as a tenant. May tell someone to vacate, they say, okay, I'll leave, but they don't pay you, then it becomes a different thing. So how to get your tenant to vacate the premises is give them a notice, and that's it. Give them a notice and an ultimatum of a period to leave, and then after that you'll have your premise. You know, when someone goes to court, they want to stop you from evicting them, or they want to stop you from locking or padlocking your premise. Then you have a backup that I gave them the notice here. I have a document to show that I don't want them there.
Yeah.
And you see, this is, as someone used to say, willing buyer, willing seller.
Yeah.
But in law, we say that you need to come to an agreement of mind to get into a contract. When you are not in the same page, then that agreement should not be there.
Okay.
Yes.
And I think now on the tenant's side,
yes,
when I'm thinking of moving into a premise, okay, so first you say that you need to get a lawyer to be able to go through your lease.
Yeah, your tenancy agreement, your lease, your contract. Yes.
What else should I look out for? Because at times you get into this place and you say the desperation is actually there. Yeah. Maybe you're moving into a new city and you need a place urgently, and you pick the next available thing. What should somebody look out for when they're looking for a new premise?
When you're looking for a new premise, and you said moving into a new city, I've seen the emerging trend nowadays is when you're really, really desperate to get somewhere, you'd rather get an Airbnb, settle, and then over a period of time look or do house hunting so that you get what exactly you want. But when you're looking out, when you're looking for a premise, when you want to get into a tenancy agreement with someone, basically you're supposed to just cross-check that you have everything that is right. It's not necessarily it does not necessarily need to favor you, but it has to be right.
Okay.
What do I mean? You need to have a tenancy agreement or a contract that shows that the person who is offering you this premise is the owner, so that you don't have an issue of subletting and then you find that both of you are flouting the rules and then you're the one who suffers. Then you also have to confirm that this tenancy agreement provides you with a backup so that you're not haphazardly evicted. You have a notice period, and then you have the backups that you have certain refunds, you have certain grace periods for you to do certain things. And then have an opportunity to look at this agreement and have your input in it. The moment you have an agreement that you're told this is a standard document, there is no addition of even a comma, then just know that you're getting in trouble.
Okay.
And then service provision. When you have instances where service provision can be provided, can be dealt with by third parties, then let's say you're told that you're moving into this premise, we shall convert the meter or change the meter into your name and then you pay directly. That's a better option. But when you have someone wanting to denote that this amount is going for electricity, this amount is going for water and all that, then you're courting trouble. What if you keep on paying and someone does not pay to the service provider and the service is disconnected?
Yeah.
So there are certain things that to look out for, but it's all can be contained in the tenancy agreement or the lease agreement.
Okay.
Yeah.
Last one. When you're moving out,
Yes.
and most times we pay rent and deposit. In Mombasa, it's a bit different. You pay 2 deposits and rent.
2 months.
2 months deposit and rent.
Yes.
Yeah, quite a shocker. Now, at times when you're moving out,
Yes.
when I was moving out, I received an email, by the way, because now there's rent and deposit. Give me
Yes.
back the deposit, right?
Yes.
But then this breakdown was my deposit. There's a breakdown of the things that they need to fix in the house. Everything, all the way to a painting brush, to the nitty-gritties.
Yes.
The nitty-gritties. My deposit I think the
Kula
balance
yacht.
was like 2,000, 3,000 and something.
Yes.
What do you do with landlords who do not want to give back deposits? Because you see, it's expensive when you're moving and you're paying a lot of money. So when it's time to leave, it becomes a push and pull where they add all these nitty-gritties.
It takes us back to what I was telling you, that you look at the tenancy agreement properly.
Yeah.
A good and proper tenancy agreement indicates that the deposit shall not be utilized as an outstanding debt for rent. That is number one. shall not be utilized to offset any other requirement. So your deposit should be intact. If they want you to return the premises to the shape, form, and color that was when you took over, then they give you that opportunity. They tell you that a few days before vacating the premises, you shall have inspection that shall be done to confirm that you've done A, B, and C. And you'll find that it's cheaper, because if, let's say, you live at a premise where you pay 50,000 per month, and then your rental deposit is 100,000 because you've paid 2 months rent deposit, and when it's time to leave the premise, someone tells you that we bought paint and we bought everything, and now we're giving you 1,000 shillings back. So they utilize 99,000 just to bring back the premises, and you are living there. It's not like the door was open, everything was broken. Then it beats logic. But this is what happens to a large percentage of people, because the moment you give out a deposit, the chances of getting it back the way you gave it is very minimal. And it goes back to the tenancy agreement that you had. If you are able to look at the tenancy agreement and see that certain loopholes are going to hurt you in the long run, then you are able to cure them, then you would not have that. And you'd be telling those people, hold up, what we're going to do is that I am going to make corrections with your person, or maybe renovate the place with a supervisor in place, or give me your contractor, we renovate the place, and then I return it the way it was.
So there's provision for that.
There is supposed to be provision for that. And if it's not there, you can orally ask for it. This is practically something that I've seen and I've experienced. When someone wanted, you tell someone that, give me your contractor. Let me pay your contractor, let me buy everything, and then I vacate the premise. And then I found out that the money that they were proposing to me, the money that I was going to use was almost a quarter of what they were proposing. Yes.
All right. Thank you so much. I think
I highly appreciate.
We have learned. Thank you for making time.
Okay. Thank you for having me, and we do wish you a good day.
Yes, have a good day. Of course, we've been speaking to Lawrence Obonyo, and it's from Lawrence Obonyo Legal Advocates. Yes, if you want to reach out to him.
Yes, you find us on the 5th floor of Imara Building in Mombasa, and then the ground floor of Diani Shopping Center. Thank you so much.
All right.